In the Karen Reed case, the Commonwealth finally puts on its star witness, accident reconstructionist, taking the place of Joseph Paul in trial 1.0. He claims to have it all nailed down as to how John O'Keefe met his demise. But does he really?
From the Lexus to John O'Keefe's phone, he's got a lot of tech going on, but does he really know what happened that night? I'm Lainey Law.
And I'm attorney Andrew Myers.
So what exactly did he talk about as far as his evidence for the state?
Well, about 6 hours of material is what he talked about. The Commonwealth placed their star accident reconstructionist, Judson Welch of Aperture, LLC. And you'll remember that name because that's where Shanon Burgess worked and testified previously with the faulty CV. Under direct examination by Special Prosecutor Hank Brennan, Welcher indicated that he relied on a lot of stuff, including police reports, photos, videos, and data. And essentially, in order to view the essential period of time during the Commonwealth's allegation that Karen Reed's Lexus backed into John O'Keefe, he used 3 sources of technical information. They were the event data recorder, similar to a black box inside the Lexus, the text stream system, which is built into the infotainment system, and also John O'Keefe's own cell phone. So he kind of put all that together in many pages of a PowerPoint presentation. And Brennan actually asked if, this is crazy, he asked if Judson Welcher, while he was on the stand, was surprised that the data system actually did not record in any manner the collision that's alleged between the Lexus and John O'Keefe. In other words, at the point where the Commonwealth claims that Karen's vehicle struck John O'Keefe, there's no information in any of these systems. And Welcher said, well, it was exactly as I expected, and he explained that the SUV weighs about 6,000 pounds, and O'Keefe weighed only about 216 pounds. So we're waiting for Robert Alessi to cross-examine on that and many other points. As we're recording this midweek episode, as we always do, primarily with viewer comments, we are waiting for Mr. Alessi to start the cross-examination. Much of Welcher's testimony focused on the early morning of January 29th, 2022, when Karen Reed is believed to have left the Waterfall Bar and headed over to 34 Fairview Road, where O'Keefe's body was found later on. Welcher showed the jury a video simulation that he created using cell phone and vehicle data of a 3-point turn that Reed's SUV made after she took a wrong turn. Then he starts diving into this data recording the SUV backing up. So as we all know, there's all this technical information and all this data from the information from the tech stream and the infotainment center. But as we all know, technical data and technical gizmos are only as good as the people that interpret them. So here's what happened when Mr. Welcher was on the stand.
Using this information to then try to tie it back to the cell phone data to make sure we have the real-time information.
Okay, what he's trying to explain here is that the infotainment system only records events, and it only records 10 seconds of information. So in about the middle of your screen, you see the words with infotainment trigger 1162.2. There's the backup. And so it would show, that 12:31:38 is when that trigger occurred. And so the only recording that would be available at this point is 5 seconds before and 5 seconds after. So if I've thoroughly confused you, listen to this.
Again, this was written back in January before I got the additional information. So what you can see is, I'll zoom in. Again, we're now talking about trigger 1162.2. We know that that's 18 minutes that the vehicle has been on.
So that would be 18 minutes since the Lexus was started at the Waterfall Bar. And he only did this starting in January because remember, Trooper Paul was the accident reconstructionist in trial number 1. And, you know, he's the guy that said, well, the evidence, the scene spoke to me. And he just wasn't really very clear. So this is the Commonwealth's attempt at trial 2.0 to clarify things. And by the way, that word was used quite a bit, clarify.
18 minutes, 57 seconds, 19 minutes, 2 seconds. This is the range. Again, the plus or minus 5 seconds. 19 minutes, 2 seconds is when the trigger occurred. Infotainment system, adding those two together, 12:36, plus the 19:7.5 indicates the end of 1162-2 is at 12:31:43.
That 12:31:43, is it based on the Lexus clock from the infotainment system?
It is. It would need to be corrected to the O'Keefe cell phone data.
So when you reconcile that variance of 21.9 seconds, what is the time?
You end up with 12:32:04. So if you simply take this and add 21 seconds to it and add 29 seconds to it, so you get between 12:32:04 and 12:32:12.
So now, Lainey, if you're in a class and this is being presented, wouldn't you want the opportunity to ask some questions? You know, raise your hand and say, wait a minute, wouldn't you?
Well, that and I mean, I'm not the professional here, but I also feel like this could be presented in a clearer manner, just the way that it's going about. But yes, I am thinking from the juror's perspective that it's becoming a little bit more difficult to follow along. And like you said, you might have some questions.
So he continued.
When you reconcile the two clocks and you have that range of 12:32:04 to 12:32:14.
12:32:12.
I'm sorry, 12:32:12.
See, even Mr. Brennan isn't sure about all of these numbers. It's just a bunch of numbers on the screen. And it seemed, I don't know, but it seemed to me they just weren't prepared. I mean, this kind of really technical stuff, you know, supposedly the different colors are used on the screen here, blue, yellow, red, white. I think I covered them all. I think those are meant usually when you do a demonstrative aid to clarify things. But I don't think this is clarified at all. I almost would bring Joseph Paul back. But and then on top of all of these numbers, these were the numbers that were shown in the infotainment system in the Lexus. You had to correct according to this witness because that was wrong, and it has to be adjusted to John O'Keefe's cell phone, which is a difference of 21 to 29 seconds. Now, if you're trying to prove something beyond all reasonable doubt, I think there's a lot of doubt here.
Does that simply accommodate the window of data, but not before and after?
Correct. So, you know, again, even on John's O'Keefe's cell phone, even within his cell phone, there's somewhere between 21 to 29 seconds difference on his cell phone. So even that one piece of instrumentation has some variance to it. So we know it's between 21 to 29 seconds at this approximate time. So this is taking into account that variance.
So the only time window that you have is based on the data, and that's reflected in the 12:32:04 to 12:32:12?
Sustained.
Is there any other window you can accommodate with the data you have other than that 10-second window?
Yes.
What's that?
So I was given information about a final lock event on the phone.
Let's stick with this window if we can.
Okay.
So he asks a question. He didn't like the answer. So this is a horrible example of just, you got to prepare your witness. You can't coach your witness. You do not tell them what to say, but you at least prepare them with this kind of complicated stuff. I mean, we're not talking about, how much are the price of eggs in Chicago. We're talking about some detailed technical stuff. And it's just, I don't know. I don't think it was presented well.
Since you only have 10 seconds of data, is it possible from the Lexus clock data to have a larger window, 10-second window?
No, the text stream will only give you a 10-second window, but it doesn't tell the whole story because the vehicle's still moving.
Understood.
Do you understand? I'm just wondering what the jury is thinking. I mean, these two guys are on two different wavelengths. Hank Brennan is asking a question, and Judson Welch is like backing up and saying, yeah.
Yeah, they don't seem consistent. I still can't get the whole time, even when we're looking at that slide before, I'm just thinking about how at school I would get absolutely roasted for presenting something like that because it wasn't clear. And if I'm the jury, I mean, right now as a viewer even, I don't really understand what they're trying to get at here.
And don't blast me down in the comments. Oh, well, you didn't give the context of the beginning of the morning because the whole morning was like this. I was trying to get some work done around the office, but I couldn't. This is like a train wreck. I couldn't take my eyes off of because the entire morning was just excruciating. The entire morning of this testimony was worse than pulling teeth. I think I would have rather have had a root canal than watch this.
Okay, continue, please.
Objection. That's calls for what's called a narrative, and that there should have been a clear objection. But Robert Alessi did not object, and I'm only guessing because they're tying a rope around their own neck. So let them do it. Let them.
So I have this other event, a lock event, and the information I was given that at 12, it's 12:32:09. And so we have the text stream data ending at somewhere between 12:32:04 and 12:32:12, which puts this number right in the middle of that, more or less.
Continue.
Continue. That's clearly objectionable. I didn't even hear an objection, but she just sustained it because that's clearly an objectionable question. It calls for a narrative answer. Remember that this is key testimony intended to shift that all-important timeline to make it fit with everything else that happened that evening so that the Commonwealth can prove its case beyond all reasonable doubt. That's why this is so important, and
it's messy.
Luncheon break? Certainly are. So why don't we do that? So we'll take 45 minutes for lunch.
So remember, you may be a better student than me, but do you remember if you were in school and you knew you were going to be called on and you knew you didn't know the answer and you knew you were going to have to kind of, do a tap dance and recess came? And it's
actually.
It's like.
He wasn't prepared. They weren't making a clear point. It is a perfectly convenient lunch break.
I mean, so it's like, yeah. Sure. Let's take a little bit of a break and we can get our act together. So
pep talk in the back room.
Yeah, they came back after lunch and they got it together a little bit.
I believe it's slide 25.
He looks red.
And could you widen the left-hand
He's embarrassed after getting yelled at in the back.
And you mentioned you measured or you ran information about distances between different routes?
Correct.
Specifically regarding Fairview to Meadows, the first box. Do you see that?
I do.
There are 3 different mileage numbers.
Yes.
And then there's streets to the left. Can you explain what's set out in that box?
Sure. It's basically 3 different routes you can go. Sherman Street, Pleasant Street, Washington, and Sherman Street.
All right. So he went on and on and on. And to be fair, they, to a reasonable degree of medical certainty, a bunch of different questions were asked, and the point of view that was presented was that, the vehicle backed up and it went forward, and it did happen if you coordinate all three of these sources that I mentioned before in front of 34 Fairview Road. The other 2 points that, two of the other key points that Welcher mentioned were that, later in the day, he went through an exhaustive analysis with slides just to give the opinion that when Karen Reed backed into John O'Keefe's Chevrolet Traverse earlier that morning, that that did not break Reed's passenger side rear taillight, according to the direct evidence. And the other major thing that was claimed by Judson Welcher was he claimed that Mr. Welcher is of similar weight and height as John O'Keefe. One of them is 6.2, the other one is 6 feet and a half, and they're both of approximately the same weight, 220 for Welcher and 216 for John O'Keefe. So what they did is they put grease paint, bright blue grease paint on the Lexus rear passenger side taillight, and they had Mr. Welcher stand there. And it turned out that if the one was backing up, that the blue grease paint transferred miraculously onto his arm, right at about the same place that John O'Keefe had those injuries. So they're trying to, I don't know, it seemed kind of fake to me, but it was presented in order to show the jury that, yes, indeed, the tail light and the arm of a person of about the same height and weight matched up. So,
about the same height. You said 6.6 and 6 foot 2 inches and 6.5, like 6.5 an inch.
Approximately, yeah.
That's an inch and a half difference. I mean, not that like.
Yeah, it was interesting. We'll say that.
About the same, about the same. Beyond reasonable doubt is what we're aiming for here, and you're giving me about the same.
Yeah, and the thing about the law is that there's a concept called substantial similarity. And anytime you're putting some kind of an experiment or demonstrative type of activity before a court, what you are showing them has to bear substantial similarity to the actual thing. And just for Mr. Welcher to say, I'm the same approximate height and weight as him, and so why didn't he go hire? Why didn't he go hire somebody from mass casting? Or want to know something really crazy? Welcher and Aperture actually went out and purchased a Lexus SUV of the same make, model, came out of the same factory and all that stuff as Karen Reed's. They actually bought another Lexus. And at least the testimony that I watched, they didn't get to how much that cost. But of course, who's paying for that? The Massachusetts taxpayers. Thank you.
So I hope if you live in Massachusetts, I hope you're happy for funding the new Lexus.
And I also thought, okay, so what? It's the same make and model, but they do things during the year. And wouldn't it also, if the height of the contact between the tail light and Mr. Welcher is so important, wouldn't there be a difference for tires? I mean,
difference for tires, and then difference for shoes. Also,
well, he said I'll stop you there. I'm sorry. He said he had the same shoes. He said
the same shoes.
Yeah, he did. He went and got the same type of shoes. But no, you're right. You're right. I mean,
are the shoes worn in? There's just so many variables.
As I keep looking off to the side because I have a monitor with the live trial, and I was hoping Mr. Alisi would be able to stand up and start his cross-examination. But as we're recording this midweek episode, we don't have that. I promise you that'll be the headline of our actually, Mr. Alisi just stepped up. Why don't we take a look and see what's going on? But, substantial similarity is just so important that I can't believe that they did it this way. I just can't believe that they just had Mr. Welcher just, go out, buy himself a Lexus, go out and buy himself a pair of shoes and say, well, this is what happened. I mean, it's just, It's nuts.
Struck it subject to going.
So we're going to join him live as we record this. Let's take a look.
Correct. There may be, depending upon what's in the video, there may be more. That's why we
Right, but the ones, all right, so. we
So I can go back and show them.
Yes.
I don't want to offend the court.
Okay.
Don't offend the court.
Anything but that.
So are we starting on slide 132?
132, Your Honor.
Okay, thank you.
Did I just hear a cat?
Oh my gosh! I didn't
Oh, that
know
was
he's
your
so
cat?
loud.
Maybe the
Yeah.
cat was in the courtroom. I thought maybe a cat did in the courtroom for entertainment.
Even my
Okay.
cat's up arms.
So I promise you in our next episode, which will drop Saturday, this is our midweek episode. I promise you that we will summarize all of the highlights of Mr. Alessi's cross-examination because, he's obviously shown everybody his great talent at doing that. And so that's what we'll do. So until then, let's take a look at our viewer comments for this week.
Yeah, so starting off with Libra in Seattle. I believe there are a lot of people from the West Coast who are watching this trial. I see a lot of locals, Washingtonians, in the chats. I've had conversations with a lot of people who live in Washington, Oregon, or California. I first heard about the case right after it became public that the feds got involved. I was immediately intrigued as an avid trial watcher and haven't been convinced that Karen didn't hit John from the start. I don't know what happened, but a lot of people are sure acting suspicious. Yeah, that's the main, honestly, and this is something that I think about too, where it's just like, regardless of all the people even acting suspicious, one of my big issues too is that you want to put Karen Reed on trial, but you have all these cops, and yeah, Proctor lost his job, but everybody else was drunk driving too on top of that. So it's just like, yeah, are they all on trial? No.
Number 2 from Springer 585 is one of the questions now during jury selection. Are you able to hold a poker face no matter what you see or hear in court? They're only human, and making a face is what we do. And that's true. And it's often involuntary.
Yeah.
What was I watching the other day? I was watching actually some of this fellow, Shanon Burgess's testimony. I was actually watching. And I caught myself. I mean, I'm talking to nobody in particular. I'm sitting at the editing booth watching this, and I'm saying, "Oh, come on! Oh, really?" And I had to stop myself because the dog kept looking at me like, "Huh? What? Who are you talking to?" But this commenter is absolutely right. As humans, that's what we do. I mean, if you're in court, you got to dummy up and not do it. But I don't know.
We laugh at our computers, even sitting in our rooms alone. Everybody watching this, I'm sure, has giggled at one point or another to our episodes, and that's not even counting the awkward tension in the room.
Yeah.
Microdots. So drop Microdots. Thank you for the shout out. I watch your show every week. Thank you for your comment, Microdots. That's very
I thought
sweet.
this was great because I really look up to Microdots. We had mentioned when we were screening the point in the trial at one point where Robert Alessi was cross-examining Shanon Burgess, and she went like this, and then Hank Brennan objected, and she said, the objection sustained, Mr. Alessi. She had a crazy smile. I mean, again, I've always tried to be objective about this case, and people don't like that, but, even objectively speaking, it was a really crazy smile. So I just referred people, go watch Microdots because he did a fantastic episode of that. So there is Microdots. So shout out again. I would highly recommend that people watch his work because it's outstanding.
And speaking of not being able to do a poker face, I don't know what's gotten into him today, but I could not hold a poker face as we got a guest visitor who really wants to keep visiting.
Cameron Ellsworth is our next commenter. She lectures the jury about making sounds and faces when she is constantly doing it. Well, as we just mentioned, yep.
Rules for thee and not for me. Brenna O'Brien, thank you for your coverage. I think Karen is innocent and framed. However, I'm curious as to what you think the chances are of a hung jury. I have heard that it's more likely when there are multiple charges. I pray she is acquitted, but want to see your thoughts since you live in Massachusetts and no level of corruption there. Well, Andrew can't speak ill of his coworkers.
Well, I have all along said my prediction, and I hope I'm wrong. And if I'm wrong, I'll be thrilled. My prediction is that we will have another hung jury because there are just so many people with so many deeply held thoughts about this. And I don't know if you can know that a jury will not, base their thoughts and deliberations on their emotional thoughts. But I hope I'm wrong about that. The trial's not over. We haven't seen the defense present their case, and so I don't know. Now, actually, as to the question, I've heard that it's more likely when there are multiple charges. Actually, the reverse is true because the reason that prosecutors will often include lesser included offenses or alternative theories is to give the jury more flexibility. If you only give them one option, it's more likely that they're going to dig in and become entrenched and just not reach a conclusion. But this way, if you've got a room full of 12 jurors and they have options, they can say, all right, we don't agree on one, we don't agree on two, but we'll go with three. Now, in the trial 1.0, actually, it was kind of the reverse, where what we heard from jurors A, B, C, D, and E in their messages to the attorneys after the trial in the summer of 2024 was that they were, in fact, unanimous on 1 and 3, and they were hung on 2. So I think actually the alternative and lesser included offenses give the jury more options. Now, as to the final little piece of information there, I have to make a little admission that I've made before, and I'm not ashamed of it at all. I don't live in Massachusetts. I went to school in Massachusetts. I lived in Massachusetts for many years. I have an office in Massachusetts. I started out in Boston. I was in North Andover for 27 years. I have an office right over the border in Methuen. But like many Massachusetts people who got fed up with Massachusetts, I live in New Hampshire, just over the border. So, but I still pay taxes and have a business in Mass. And I've been practicing law up to the present day for over 30 years. So there, I gave away my big secret.
Dun, dun, dun.
I know, really. So we got 2 new countries this week. And we're up to 72. We're up to 72 now. Our viewers, they always challenge everything and anything we do. Somebody pointed out to me that Hong Kong is part of China, and I have China and Hong Kong on the list. I'm going to leave them there. And I think a lot of people know why. Hong Kong is not happy being a part of China. China is not happy with the fact that Hong Kong is acting very independently. So technically, my commenters are right, but I'm leaving it that way. So big difference. It goes from 72 to 71. It was now, I think it's been 3 weeks since, our viewers, I do listen to the viewers under their pressure. I said, all right, we're going to start keeping track of states. And in less than 3 weeks, we got all 50 states, District of Columbia, Puerto Rico, and Guam. So with that, we now go to the Brian Koberger case.
So Christine 005, can't the court put a hold on the book release? I don't know how they got on that. Yeah, that's none of their business. It might even be like people can publish books in different states and stuff. There's nothing that anybody'd be able to do about that. Other countries even,
Yeah, we mentioned this in our last episode. Under constitutional law and First Amendment law, there are different levels of scrutiny, different levels of the manner in which the United States Supreme Court addresses constitutional issues. And prior restraints are very much disfavored by the United States Supreme Court and any other court that, even thinks about it. And no state court really has jurisdiction to even bring a complaint to stop the publication of a book. So the answer to that is no. Number 4, of course, we had our friend Yoli on the last episode. Agree with Yoli. Strategic when the state changes, hides, twists, outright lies about, and now leaks information regarding their story. It screams corruption. It's not about who listens to Dateline. It's about exposing corruption in law enforcement regarding this case. Yes, Ann Taylor keeps screaming about the same things and needs to until the deaf ears open up and act on it. Hopefully she's been heard. So remember last time we encouraged our viewers, who's right, Yoli or me? I'd say, to be honest, the scales were tipped a little bit in her favor. So. Okay, we're honest. We're honest. Even at my own expense.
Jennifer 4L2VZ. Already one fictional book out. MSN or mainstream media and Patterson book is absolutely ridiculous. So much going on in this case. It's obvious something is wrong. It's one of the big issues. And I think as technology and the internet and TikTok and all these things advance, I think it's going to get even harder in the future to even decipher these types of things.
Yep. I mean, people want information. In this case, so much information has been secreted and sealed and protected by the gag order. And I think I said enough. Oh, number 2, Plant Ando Pura Vida. I think most people won't read the book. However, there will always be someone that will read it and make comments about it from their point of view, leading to make people see the case through their eyes. There's even a book with all the details kind of thing. Yeah, that's probably true. People talk, it's sad. People don't read as much as they used to in the old days. But there have always been, quickie books. I remember Son of Sam during his whole reign of terror in New York. There were quickie books back in the old days. You'd get them at the 7-Eleven store. Bernhard Goetz, the subway guy, there was a quickie book on him. Before Ted Bundy's trial 1 and trial 2, both, there were quickie books. You go into a convenience store and there'd be a book right there in the counter, because in those days people read. In those days, books were a big seller. You go to the beach in the summer and people were sitting around reading. You'd get on the subway to go into the city, and I'm sure it's true with every city, but I commuted for years and years and years in Boston on the Green Line and the Red Line, and people in the old days anyhow would sit there reading a book or the newspaper. It just doesn't happen anymore. Now everybody's on their little devices. But anyhow, there have always been books like that. I'm not saying it's right. I'm just saying that there's a thirst for knowledge, and people want to know what's going on.
Yeah, everybody's going to be watching the YouTuber who reads the books.
Yep.
All right, our last comment, Teresa Ponton, I9J. Big deal, no worries. Nobody watches Dateline. That's what Andrew said.
Well, yeah, so people tended to agree with Yoli that her view, I don't speak for her, but she felt that the more important point was that, if something's wrong, that there was a leak, and it damages the chain of evidence. It damages the whole presentation of the case. It damages the potential ability to impanel an objective, unbiased jury. So that's fine. My point was, and I really took it in the comment section, my point was the ratings show that Dateline isn't what it used to be in the old days. Things like 60 Minutes and Dateline were huge. They were huge. People watched them. But, anymore, not really. And I stand by that. I mean, people said, "Oh, Mr. Myers, you don't know what you're talking about," because, it's the ratings aren't important on TV, because most people watch this streaming online. Yeah, I don't know. Show me the data. Show me the data, because I don't know. I just don't think. I think if people are watching stuff streaming online, they're watching games, they're buying stuff on Amazon.com, and they're gambling. Those are the 3 top things that people do online, not read true crime books.
There's
to my own detriment, because we have our own little true crime channel here, which is past 20,000 viewers. Thank you, or subscribers, I should say.
What I was going to say is, speaking of our podcast too, is just like they're more likely to watch the podcast or talking about Dateline than they are actually to watch the Dateline itself.
Yeah,
that's how
exactly.
I feel.
And that's, people are chopping it up into pieces, as we have to do a fair use. We can't show large portions of it because of copyright infringement. But I don't think the big legacy media, and more specifically, this particular show on NBC, I don't think they have the sway that they have over the American public opinion. So anyhow, we always mention at the end that this case does involve the 4 young people that lost their lives on November 13th, 2022 in Moscow, Idaho. Kaylee Gonsalves, Madison Mogan, Xana Kernodle, and Ethan Chapin. And so we do certainly hope for justice for everybody in the case. So that's my closing thought. We forgot to ask people to like, subscribe, help us out here. We're at 20,000. My next goal, and I know Lainey will get mad at me, but my next goal is 100,000.
Yeah. You guys are gonna help us get us to 100,000, right? You guys gotta help me out here, or else I'm gonna have to deal with it. Be sure to comment down below with little palm trees emojis as we're beginning to welcome in the warm weather after Memorial Day. So I hope everybody's getting ready to have a phenomenal Sunday. I know Karen Reed and her team aren't going to be, but you know, we can still enjoy the summer, guys. So thank you guys so much for watching.
I'd like some warmer weather. I was out working in my garden this weekend wearing a hoodie on top of a shirt and long pants. I mean, yeah, where's this warm weather? But in New England, that's what we're used to. Okay, thank you very much for viewing. And I promise that we'll have more in the cross-examination of Judson Welch in our next episode. Have a good one.
Whether you are in the grocery store, the gas station, or anywhere else, please remember to be kind to people. You don't know what they're going through. And the same goes for our comment section. We want you to comment, but be nice, be kind, be positive if you can. And thank you for watching. Be sure to like and subscribe. Have a good one.
I'm actually wearing the same make and size shoes